Chris Whitelaw is our resident lawyer, or not lawyer, barrister, in fact, and I'm just going to read what Chris has written down for us, because Chris is all about protecting you in the likely event that something adverse will happen. If you do what we do, you make yourself more visible. And mostly the adversity will come from a competitor. That's my experience. And Chris will no doubt share his experience with you. So if you just indulge me for just one moment, I just want to read this to you. Chris has 30 years of experience in the law, and principally in commercial law, negligence law, and consumer trade practices law. He's a practicing barrister, accredited mediator, commercial arbitrator, expert in early management resolution of commercial disputes, and I'm a big fan of that. He's also a business owner himself and a director of 3 companies, online companies for that matter. They're web businesses. The title for Chris's talk today is 5 Chief Areas that Business Owners doing business online need to know about. So that's exactly what Chris is going to be sharing with you. But I want to add that we are also using Chris's services where Street Smart business builders are concerned, and we're also recommending that our clients do. So obviously that's a very, very strong endorsement, folks. Finding the right people in business, it's all about Chris being part of our faculty. You will be treated with priority. Can I say that with confidence, Chris? So can you please welcome Chris to the stage? Thank you very much, folks.
Thank you, Mal. So am I wired up okay? My voice at the right level? Oh, that's good. Just out of interest, just to begin with, how many of you here saw me speak down in Melbourne earlier this year in May? Okay, quite a few. So the reason I asked that right up front is because that particular 1.5 hours I did there was about how to bulletproof your business against future disputes, future litigation, and what I called hefty lawyer fees. And I know about hefty lawyer fees because I've charged plenty of them when I used to be full stream into the litigation stream of work. Those of you who weren't there and would like to see that presentation, and not just have a copy of those slides available to you, but also to have access, and this is to all of you here, a webinar that I did a number of weeks ago where you can watch a replay of that. So you'll have the slides and you'll have all my commentary on those slides. Just, if you're interested, leave your details at the table over there, and they'll give me that list, and I will make sure that you get, in due course, an email with a link where you can go and have access to all those things. So I have a lot to get through today, and I only have an hour for this session. So I'm going to say to you right up front that this is going to be rather technical, and I know when I've watched other people up here presenting, they have lots of nice pictures and things like that, which of course is what they say you should do when you're doing these presentations, don't have too many words. But I'm going to tell you right now that there is a fair amount of words because this is a technical area. And really my being on the education faculty, and I'm not here to at the end sell you something, but to give you education and give you content. In some ways, what I'm doing with you today, and I speak to many groups of lawyers as well, and of course they're highly technical presentations, what they want, and what I'm going to assume that would be useful to you today, is you need to have something that you can take away. So you'll see on my slides that in fact there is a fair amount of information, but you will get a copy of those afterwards. And not only that, because every time after these I will do a webinar, and you'll be invited and you'll be told about that, you'll be able to get that webinar replay as well. So the idea here is to resource you in an area that maybe you don't know enough or as you should. And so when you get this, you'll be much better resourced. So, make sure so who am I? So I'll just put that up there for you to see. And you will have, of course, some handouts on there. They're just flyers and things that I brought with me here from Sydney. And because I was in a bit of a rush, because I'm involved in a court case actually in Sydney at the moment, and that resumes again tomorrow, I just grabbed whatever I could get my hands on and stuck it in my briefcase. And I didn't know what the numbers were, so there'll be some of you at tables where you won't have enough to go around. Once again, if you want to have those flyers, just leave your thing at the table there, just saying you would like it, and we'll make sure that they're sent out to you. So I put that up there because in addition to what Mal says, I just want you to see exactly what my background is so you know what my relevant experience is to speak to you today. So a lot about being on the faculty here, and particularly in the area that I present on in this area of the law and what's relevant, and trying to help business owners in what many of people think is too complex, too difficult, and so on. And of course, what that means is that when an issue comes up, one of the immediate difficult issues for business owners is, you know, when is it too much? When should I say that I now need someone to help me? And of course, if you're a new business or you're a business with tight cash flow, the reality is that you will defer going to see someone who's going to charge you dollars from the moment you walk in their door for as long as you can. And your other worry will be that if I'm really not sure where I stand right now, and I'm really not sure exactly what's going to help me, but I have to go, if I'm going to go through the door of a lawyer, how do I really know that I'm going to get what I want? And how do I know that I'm actually going to get something that helps me, but I'm still going to have to pay for it? So these are just like practical issues. This is the reality of the situation. And so what I'm offering to you, and by being on this faculty, is to say it doesn't have to be that way anymore, because the way I'm trying to work with street smart clients, in the same way that I do with people who find my website and come to me directly, is I don't believe that anyone should be charged a cent until we can work out precisely where you are now, what your issues are, and what can be done, and to lay it out very clearly for you. At that point, people, as with everything else, feel comfortable to make a decision to go forward and to spend some money. So here there are many ways, no cost at all, that you can stay in touch with me, liaise with me, communicate with me, have a conversation with me, where there's no cost at all. So we're going to cover 6 critical issues today. And these are consumer protection laws. These are all things that people having any presence online will have to be aware of. Privacy laws, data protection rules and regulations, intellectual property rights, e-commerce issues regarding contracting online, and cyber crime risks. Now, again, I only have an hour, so I'm going to say to you again before I start, in some places I'll be going extremely fast, in others you'll only be getting a very small summary. And the reason for that is there's going to be follow-up. And in the follow-up will mean that the rest of what you don't get today will be added to this, and you'll be given access to it at your leisure, and you can review it at your leisure. But before I get stuck into the heart of it, I was here very early this morning, and I saw Ian presenting from the stage, and I saw him talking to people about the Millionaire Makeover and the Shock and Awe. And I was really impressed by what I heard, and as I was watching and listening, I decided that actually I wanted to throw something in there as a bonus. So I didn't even know that that was on. I just happened to arrive at that time and so on, so I wasn't able to say anything while Ian was here, but I've said that I did want to throw something in to anyone who today chooses to sign up to those major products, the Millionaire Makeover and the Shock and Awe. And this is the offer I put together for anyone who's still thinking about it, and I'll just let you know. What I'll do as the bonus here is that you'll see when we go through here, one big theme of mine is that you know, a lot of problems, the seeds of future disputes, of future problems, starts at the very beginning of a business relationship or the beginning of a business, in that things that should be in contracts are not in contracts, or things that business owners put in contracts are not put in the best way. they're not put in a way that gives them maximum protection, and they don't have things in their contracts that can safeguard them and protect them and give them more control over future events if those future events happen. And these are the events that can lead you into expensive disputes and possibly into litigation. So my offer today to those people who purchase those two products is that I will review for free any business contracts that you want to send over to me. I will review them and I will give you a summary of advice on how I think your business contracts can be improved. Now, the normal value on that, of course, varies depending on the size of the contract, the complexity of the contract, and so on. But using averages, and my charge-out rate normally is around $440 an hour, would be somewhere from about $800 through even up to $2,500. So that's the potential value, or that's potential cost to what I'm offering as a free bonus to those persons who choose to purchase those products today. And in relation, as an added bonus to anyone who purchases anything else from Street Smart today at this conference, I offer them a free consultation with me, and I don't put a time limit on it. That those consultations would be either by phone or by Skype. So that's my special offer for today. Thank you. So let's get into the heart of this. Consumer protection laws. Right? This is an enormously important area, and if there's an area where you could easily fall into trouble, it's going to be here. There's a whole big area of law in this area of don't mislead, don't deceive. It's very, very big in this country. Don't make any material misrepresentation, false representations about your product or service. Don't make any representation about a future matter. These are things that it's easy to do if you're not conscious of your obligations under consumer law. For instance, something you say you will do for the customer, and that you shouldn't make that representation if you don't know for certain that you can. Don't promise something that you're not certain you can deliver on. Make sure that your customer is properly informed before they buy. These are the key principles. And if you can stay clear here, you'll by and large be good, be fine, out of trouble. So here's some examples of false and misleading representations that might come up for people with e-commerce sites. Goods of a certain standard, quality, value, or grade. If you misrepresent, you could get into trouble. Goods are new when they're not new. Goods have certain performance characteristics or benefits. You represent something, but it's not true. Someone can attack you. Misrepresentations about price. You have to be very upfront and accurate and clear about price, so there's nothing comes out of left field and surprises people later. Availability of facilities for repair of goods or spare parts. Being very clear about the place of origin of the goods. Concerning the need, what the need is for goods. If you misrepresent about that, you could fall into trouble. Concerning the existence, exclusion, or effect of any condition, warranty, guarantee, right, or remedy. So I said to you, this is going to be a bit technical. You'll have these slides, but these are the things that you, when you're setting up your business properly to monitor how you're going to do business online, these are the things that someone in your business has to be keeping an eye on. So consumer protection legislation. It's now all under this umbrella of what's called the Australian Consumer Law, which comes under the Competition and Consumer Act. It used to be the Trade Practices Act. Now it's called this. And the mirror of that legislation that's in all the state fair trading acts. And I give a link there to a site, which is a government site, federal, which I had a look at and which is a great place to go as a primer. It's a great, easy place to go just to check up on things, and you should all have that, you know, in your bookmarks or wherever else you keep them. I use Evernote. It's a great place to store sites for quick reference. If anyone doesn't know evernote.com, I'd check it out. So why have a new law? The Australian Consumer Law, ACL, will benefit the Australian community by giving Australian consumers the same rights and protections wherever they are in Australia, simplifying the law and reducing business compliance burdens by replacing provisions set out in 20 existing national, state, and territory laws with a single national law. And creating a national enforcement regime with consistent enforcement powers for Australia's consumer protection agencies to take effective action. There's a whole process of this consolidation or this coming together of all these disparate laws that we've had around the place, and it's not just in this area of consumer, it's happening in other areas as well, such as in the area of defamation law. And at the end of the day, you know, I mean, the political hurdles are always there. You know, getting those attorney generals together and discussing and working out, you know, what the right balance should be between state and federal law and so on. So it is complicated. But the more we can get this uniform laws, I think that's better for everyone. It gives consistency and certainty. So here's some key concepts. So, you know, I deal with this on a regular basis. But I guess, you know, when I'm speaking to a group of non-lawyers mainly here, you know, I need to put it in a way that's going to make it accessible to you as much as possible. Here's a very important point, and a point that many, many people don't know. Because when someone is attacked by something, they'll say, but I never intended it. But as far as the law is concerned, with this consumer law, of your obligation not to mislead or deceive, not to make misrepresentations, intent is irrelevant. It's judged upon objective fact. Was it false? Did it mislead? That's all they care about. You can have the best intentions in the world and still be at the wrong end of the stick. So these are the main ingredients. So if you came to me as a client and I was looking at this, these are the things I would have to look at. Did you make a statement of fact? Was it true? Was it false? If it was false, did it mislead or deceive the consumer? There's a causation thing here. Has to be followed through. Did the consumer rely on the representation? See, some people will say, well, you didn't tell me the truth, but when you investigate it, you can actually find that they knew that and they didn't rely on it at all. So that action would go nowhere. And as a result, they suffer some kind of a loss. Those are the ingredients. In some circumstances, silence can constitute this misleading or deceptive conduct. And again, this is an area where it's easy to fall astray if you don't know this. You may think, I just won't say anything about this. If I don't say anything, I can't possibly get in trouble. But no, you can. Because of if there was something clearly you should have said to the person you're doing business with, that you're transacting with, that would have made a difference to their buy decision, well, you have an obligation, if it was material to their buying decision, to let them know. Making false predictions. And the key thing there is when you have no reasonable objective basis to give a prediction about something you're selling, don't give the prediction. Some more key concepts. Disclaimers and exclusion clauses, right? Everyone has heard about these, but a lot of business owners really don't know how to use them properly. And this is where they often fall into the trap of finding something that someone else has used, or going online and finding something and grabbing it and doing the cut and paste. If you don't understand what you're doing there, well then it's an accident waiting to happen. Well-drafted disclaimers and well-drafted exclusion clauses can be used to limit your legal liability. But you can't you can't use them to circumvent statutory consumer protection laws. Some people think they can, but you can't. If you engage in misleading or deceptive conduct, and as a result, a consumer of your product or service suffers financial harm, you cannot hide behind a disclaimer or exclusion clause. But the consumer must prove that he or she relied on that conduct complained of. This might be difficult to prove if you can show that a certain well-drafted disclaimer or exclusion clause was clearly notified to them, given to them, and that negates that reliance. So make sure you have well-drafted disclaimers and exclusion clauses. Privacy. This is the next area. Very big, important area for anyone operating online. Privacy and data protection. There's an enormous amount of personal information being requested and supplied online. This is part and parcel of e-commerce. The fact is, the fact that it's voluntarily supplied doesn't mean that a consumer is releasing control about how that personal information is to be used. Every website should have a published privacy policy and terms of use. And even if you have one, if you haven't critically looked at it, if you just had someone give it to you without you making any critical evaluation against certain benchmarks, well, then that means you have no idea whether it's effective or not until something comes along your way that you don't like, that could have been avoided by you properly evaluating it. The website owner must fully comply with applicable data protection laws and regulations. So I guess you need to know them so that you can do that evaluation. Loss of control of personal information online can be the result of unauthorized disclosures, access and use, or it can result from the collection and use of data for advertising, behavioral activities, and data profiling activities. I mean, this is big business. Everyone in marketing wants to know about the consumer and wants to know their profile. So they want to get hold of any information they can, but you have to get it in the right way. Surveys show, and they do regular surveys, show that internet users do object to their personal information being used in ways in which they didn't consent. They particularly object to that information being used to invade their personal space by unsolicited email, direct marketing strategies, and so on. In Australia, privacy and data protection is covered by the Privacy Act, which is a Commonwealth Act. It contains the key principles that govern the way in which a business can collect, use, store, and disclose information to identify an individual. These principles are called National Privacy Principles, and they'll soon be called Australian Privacy Principles because there was the Australian Law Reform Commission has recently done a big look at the privacy laws and made a lot of recommendations, and so there's going to be some changes. However, small businesses with an annual turnover under 3 million are exempt. So for most of you here, you're probably exempt. But you still need to pay attention to it. Based on the Bureau of Statistics figures from June 2009, 94% of businesses in Australia have annual turnover of less than 2 million. Hence, the majority of businesses have no legal obligations under the Act, but any business is free to elect to opt in to the National Privacy Principles by registering with the Federal Privacy Commissioner, which is now part of the Australian Information Commissioner. And why should you do that? Because it's going to be better for your business to do that, because of the fact that people won't trust you if they don't see that you're doing this. So you have good commercial reasons, even if you're not legally bound. You're doing it for good commercial reasons. The public operates on trust and credibility when it comes to your website. Here are the 10 key privacy principles. Let's go through them pretty quick. So only collect necessary personal information to conduct your business. Information must only be used for the purpose for which it was collected unless consent is given for other uses. And you can seek that consent. Reasonable steps must be taken to ensure that the information is accurate, complete, and up to date. You must take reasonable steps to prevent the misuse, loss, or unauthorized access of personal information. And you must clearly document and make available your policies regarding the use of personal information. So you see, that's a fair number of things for you to take on board, be aware of, and do something about. And the purpose of today is to elevate your awareness to a higher level so that you can critically look at what you're currently doing and where you're going and make sure that you are addressing these issues when you should in order to avoid something coming out of left field because you weren't aware, because you didn't know what you didn't know, and now you do. Individuals supplying personal information have the right to access the information and correct it. You have to give them that facility. And access should be granted upon request. If your website doesn't permit that, you're not complying with this principle. Individuals have the right to remain anonymous when dealing with an organization, wherever that is practical and lawful. You are restricted in the collection of information of a particularly personal or sensitive nature, such as race, politics, religious affiliations, etc. In June 2010, the government released 13 new Australian privacy principles in an exposure draft, and it plans to introduce a new privacy bill into Parliament that will implement 98 recommendations of the Australian Law Reform Commission. So changes are afoot. The Act permits use and disclosure of personal information without consent for specific direct marketing activities. The aim of the Act is to control how organizations use personal information rather than to grant individuals a right of privacy. A business can use non-sensitive information for the secondary purpose of direct marketing to the provider of the information if it's not practicable to obtain the individual's consent before the marketing occurs, and if the person's given the right to opt out of receiving such marketing. The online business must provide a prominent statement advising individuals of their right to opt out of receiving such material. So you stick to those guidelines. These permissions are given under the Act to do direct marketing. The main concern regarding use of personal information for marketing purposes relates to the collection of non-personal data such as browsing patterns, which can lead to identification of an individual. This is referred to as behavioral advertising. Businesses are legally obliged to maintain confidentiality in respect of information imparted in confidence, such as credit card details. The central obligation is that you must take reasonable steps to keep personal data that you collect secure. And in Australia, there is no mandatory requirement to notify breaches of security that allows personal data to fall into the hands of third parties it was never intended for. It has only voluntary notification guidelines. Spam. We've heard a lot about that over the years. I'm not sure how many people, though, fully understand the spam laws, so here it is. Electronic junk mail, no consent, unsolicited, comes all governed by this Act. The Spam Act 2003, because the Privacy Act didn't outlaw it, so they had to fill the gap. The Privacy Act actually allowed organizations to collect and use personal information for the primary purpose of their businesses. So if the primary purpose was spamming, then the Privacy Act permitted the business to use spam to collect information relevant to the business. That's why they had to close the gap. The Privacy Act also allowed a business to send direct marketing material. We covered that before. So it covers emails, instant text messaging, and short message services, the SMS, but doesn't cover telephone and fax. Spam must be commercial in nature. Private messages to individuals are not covered by the Spam Act. It's enforced through the Australian Communications and Media Authority. It will not be spam if the sender can show that the receiver has a reasonable expectation that your message will be sent to him or her electronically. But you need to put in the unsubscribe option. It applies to spam originating in this country and sent anywhere in the world, and also to spam coming from overseas to an address accessed in Australia. If you have consent permission from the recipient to send emails, your emails must provide full contact details, name and contact details of the sender, and must allow the recipient to unsubscribe whenever he or she wants to. The Act prohibits the use of address harvesting software and the use of lists generated through the use of such software for the purpose of sending spam. See, the other day I was approached by someone who said that she'd been to an internet conference and she had purchased some software which she said, I can give to you for $150, that will, once you load it in, will scan the websites in your area of businesses and harvest for you all their addresses. Well, at the time she told me that, I wasn't quite sure until I checked it out whether that would breach these laws or not, but it seems based on this that it would, because it's a harvesting exercise, and I don't directly had not directly obtained their consent and permission to send them emails. But on the other hand, by putting up your website and you know, it might be in some cases that by putting your details up there, there's a reasonable, you're sending out a message that you want people to use your details to contact them. So possibly, if it came to the argument, maybe it isn't. Maybe it's within the exclusion. So penalties can range from $220,000 for 1 day's contravention up to $1.1 million. But in truth, it's more likely to consist, at least in the beginning, of warnings, infringement notices, and court actions, unless it's a very, very blatant and extreme example. E-commerce, the electronic information age. The law fully recognizes the validity of electronic documents and signatures. So the law had to adapt. It came from the age of paper, it moved into the age of electronics. It had to adapt, because otherwise, how can you properly conduct your business? So obviously it had to do that. It had to give equivalence. And the government wants to create a supportive legal framework for electronic commerce. The Australian government has passed legislation to implement the United Nations Commission on International Trade's model law for electronic commerce. It's done this by enacting the Electronic Transactions Act. States and territories have passed model laws. Contract law applies as much online as offline. Contracts can be made online. Initially, there were problems in contracting online because of requirements that some contracts had to be in writing and signed, and the laws didn't cater for that, so there was confusion. There were additional problems such as establishing with sufficient clarity the identity of the contracting parties, the existence of an offer and acceptance when the contract was formed, proving the authenticity of the contract. These are all the key ingredients that come up in contract cases. The integrity of electronic communications and the admissibility of electronic evidence of a dispute arose. All these things had to be addressed. So Australia has implemented most of the model law, and this covers formation of contract by electronic means, governance of electronic contract performance, characteristics of valid electronic documents, recognition of electronic signatures for legal and commercial purposes, and computer-generated evidence. Key element, number one, in writing. So it has equivalence now, the electronic document. And I tell you, these days, even in court cases, a huge amount of stuff now is done electronically, and it's just going more and more that way. It means less time that lawyers have to go to the actual physical courthouse in the early stages. Things can be done electronically. So it must be able to be accessed for subsequent reference. If a person is required to provide information electronically, he or she must comply with the requirements about the type of software or electronic communication to be used and requirements relating to verification of receipt. Signature. Electronic signature is any means of electronic authentication of the identity of the person and their intent to be associated with that document. It can include an encrypted digital signature. Some of you are probably already using this, I'm sure. You can use an electronic signature to replace a manual signature to show you approve certain information in the electronic record. So you can use an electronic signature to replace a manual one, but this will not prove the integrity of the electronic record. So this is a very big thing. You know, if you don't have sufficient a proper system, machinery to establish authenticity, then you might say, well, look, here's something that shows that there's an electronic signature. But you may still have a problem on your hands if the person can impeach the way in which your information is kept to show that it's not, the integrity is in doubt. See? So you need to be very aware of that particular factor. I'm getting stuck here again. Oh, there we go. So production of the document. So system of keeping the document must allow its production so that it can then be equated to a paper document. The integrity must be maintained. The information must be accessible for further future reference. Retention of the communication, it must be available for subsequent retention. If it has a paper equivalent or duplicate, that must also be kept. The origin, destination, date, and time of electronic communication must be shown on the communication. See, there's a lot of little points here, easy to overlook. Proof of dispatch. The Act provides default rules for determining when and from where an electronic communication is sent and when and where it is received. Proof of attribution. The common law rules apply in this area. A person who claims to be the originator of an electronic communication will only be bound if, in fact, it was sent by him or her or with his or her authority. These are all issues that come down to proof. So if your system doesn't facilitate easy proof, it may be deficient. A business that's engaging in e-commerce transactions must be using software that will allow it to satisfy these rules that govern online electronic transactions. Failing to do this could lead to dire consequences if someone who you do business with chooses to challenge a transaction on the basis that one or other of these critical elements isn't satisfied. Thanks. Online contracts. There are many legal issues here to do with online purchasing and selling. Offers and acceptances can be made electronically, as stated. Common law rules for contracting have been adapted to the online environment. There are business-to-consumer contracts and business-to-business. Business-to-consumer contracts must ensure they don't offend consumer protection laws. The main point of difference between online and offline contracting is in the way in which information is provided to a purchaser and the way in which communication between the parties takes place. That's the key thing that needs to be looked at. So a number of persons buying online is increasing. I think we all know that. A survey done in 2010 found 88% of households were using internet to purchase goods and services. 90% of businesses have internet access. 25% of businesses receive orders via the internet. 94% of all large businesses have a web presence. Australian business internet income increased by 15% in 2009 to 2010, representing 143 billion. So contracting online is big. So I put this up here again just because non-lawyers may sometimes get confused in this area of what the law regards as a contract and what is an invitation to treat, which is not yet a contract. A contract is formed when there is a clear offer to an identified person stating specific terms for acceptance. And when you see this and take it back to your business and you look at what you have on your website, you need to reference it to this so that you can clearly understand on your different web pages where are you actually using an invitation to treat and where are you actually spelling out a clear offer that once someone responds to it constitutes a contract so that you're the offeror and they accept it. Whereas an invitation to treat is you're putting up something where you're then waiting for a member of the public to act on that and put an offer to you that you accept in a particular way online. An invitation to treat is when a business selling products or services from a website simply makes a proposal to the public at large to form a contract. It does this by putting up products or services on its site with information about the products or services and its price. It's no different than if you just walked into the supermarket and you look at the things there with their prices, you pick it up, and when you take it to the exit, to the checkout, you're offering to buy it, and when they accept it and take your money and give it to you, they've accepted it, and then you finish the contract. By doing this, it's telling the public who finds the web page that it is inviting them to make an offer by following the call to action steps. So here are the key elements in electronic contracts. It's usually commenced by use of an automated messaging system, sending an offer out to a natural person via email, requiring the recipient to take certain steps to create the contract with the business making the offer. There is no verbal communications of an offer or of an acceptance. There is no formal signing to confirm the parties have an intention to enter into legal relations. These are all the typical things in the non-online world that take place in contracting. There's no visual identification of the parties. So you can see it's a very different sort of environment. The identity of the sender may be unknown or not easily verified. The contents of the document that makes the contract may not be capable of authentication. For any contract to be enforceable, it must be possible to prove that each party agreed to certain terms. As there's no face-to-face happening online, there must be an adequate notice given of the terms and conditions. And these are things you need to very carefully check on your website. The law provides rules on what must be done to satisfy the requirements of giving satisfactory notice of terms and conditions. Essentially, the baseline is that you can prove that you gave notice and how you gave notice so that there's no doubt that the buyer had noticed before they made the decision to buy. You must be able to prove the chain of notice leading up to the acceptance of your terms. If there's a deficiency in that chain and someone wants to have a dispute with you, you may find that you're in an uncomfortable position. Types of online contracts: shrink wrap, click wrap, web wrap. Now, this is what we started off with many years ago, right? So you all were familiar with that when you got software. I'll just quickly click through these and you can read them. So that led to a number of court cases. And many of those contracts or alleged contracts were struck down as unenforceable. Key thing, a purchaser must be given the opportunity to read and then accept or reject the terms. That's the essential thing. So in click wrap, when a purchaser visits a website to purchase some goods, purchaser is required to click on I agree button before proceeding. The I agree button refers to the vendor's terms. Vendors must ensure that the terms being agreed to and accepted by the buyer are clearly written and easy to read before buyer proceeds further with the purchase. Adequate notice must be given. If all this is done, then failure by buyer to read the terms is no excuse. They can't undo the contract because they chose not to read what you made available to them. In web wrap, these contracts involve the provision of information on a website which user downloads after agreeing to terms of the download. These terms might state how the user is able to use the information once it's downloaded, e.g. whether they can use it on their own site, disseminate it to others, use it for commercial purposes, and so on. So the person who's allowing them to do that sets the terms of the use. Usually information cannot be accessed, copied, and downloaded until the user has clicked a mandatory I agree. The terms must be clearly visible and clearly stated before the user is required to agree. It's okay to provide links to terms and conditions as long as it's made clear to the user what they need to do to access and view the terms. So here's some concerns. Most of us don't bother to read or properly read the terms and conditions on online contracts before we agree. Who would agree with that? Yeah. Because we assume that the contract's not negotiable. So what's the point? Or we just don't have the time. We're too busy. We prefer to rely on reputation of the vendor. That's the credibility trust factor. Trust is a key factor for consumers. Buyer concerns. Research has consistently shown consumer concerns re protection and use of personal information. This highlights the need for every website that sells online to have a properly drafted privacy policy that is easily detectable by any visitor to the website. So I really stress that if you haven't reviewed yours, if you haven't had it checked out, it's time to do it. Recent research has shown that online consumers will pay a lot of attention to the visual aspects of an e-commerce site, more so than to content. Many will assess credibility of a site based on its overall visual design. Studies conducted of e-commerce websites have found that too many sites fail to provide adequate pre-purchase consumer information. So I'm giving you a checklist basically here. You can take from this and make a checklist out of these slides. Fail to provide adequate pre-purchase consumer information, including delivery of charges, return policy, privacy notices, and security features. Recent research conducted by ACCC of the top 1,000 consumer websites found that 50% of them attempted to, this is really interesting, disclaim responsibility for the accuracy of the information on their sites. 50% had disclaimers of warranty clauses. So in other words, they're saying, I'm warranting this, but now I'm disclaiming it. And 66% tried to limit their liability in some way. So, you know, again, if the credibility and trust factor is major in the consumer's mind, if these things are appearing, well, that may unsettle that trust and credibility. A smaller study conducted in 2007 examining e-commerce websites' terms and conditions found that many had disclaimers that conflicted with their contract terms, and many were breaching their legal obligations to consumers under the Australian consumer law. Some sites had disclaimers that tried to exclude liability in relation to goods complying with their description, quality, and fitness. Overall, these recent studies have shown that many online businesses are engaging in misleading or deceptive conduct or providing misleading representations to consumers. Some websites use disclaimers that try to limit the time frame in which a consumer has to return defective, faulty, or damaged goods. Your obligations under consumer law to provide transparent, effective legal protection, to pay due regard to the interests of consumers and act in accordance with fair business advertising practices, to disclose relevant information to consumers about yourself, your business, about your goods or services being offered, and about the terms, conditions, and costs associated with transacting with you. Bottom line, you need to ensure that the consumer is sufficiently informed to make an informed decision about whether or not to enter into the transaction with you. Before purchase, the consumer must be able to identify precisely the goods or services he or she wishes to buy, be able to identify and correct any errors or modify the order, express an informed and deliberate consent, etc. You have to provide the consumer with easy-to-use, secure payment mechanisms and information. You need to provide an appropriate dispute resolution and redress mechanism. It's in your interest to do this. So, here's what should be, the guidelines say should be on your website. I'm going to have to keep rushing through this now. Okay, there's quite a few things. As I said, this is a ready reckoner checklist that you will have here to go through afterwards. Okay, I'm just letting you read that there because I need to move ahead. Okay. Clear information about how you handle personal information, how you're complying, because this is the credibility thing, with these national privacy and personal data protection laws, secure payment options, clear information about how you achieve security on your site and how the consumer will be protected. And how to make complaints. Okay, we're pretty close to the end now, so I'm going to be okay on this. This slide here is about as far as I'm taking you, unfortunately, on intellectual property. And I think you know that intellectual property covers copyright, trademarks, and patents. I could do a whole hour and a half on this, so it's just not time. But I'm going to give you information on this. So when you, in the follow-up here, and you're given, you make it clear you're interested, and I will then send you a link, you will be able to pick up something from a Dropbox that will have this fully developed for you. And if Mal and Ian want, I'm happy to do specific webinars on each of these matters, because I know how important it is. And I know that these are areas that you can get dragged into horrible disputes and litigation. But there are things that you can do and should do to minimize that risk. So it's very worthwhile to do a webinar on each one of these things. Copyright's an area that I specialize in my commercial practice. I'm not a specialist in trademarks and patents. They themselves are very specialized areas, and some of you would know, if not most of you, that when trademarks are involved or patents are involved, there is a breed of lawyer or attorney out there called a trademark lawyer and a patent lawyer. Essentially, copyright is when you have your great idea, there's something that's going to make your business, make its millions, and you formalize that in some material way, that you put it down on a piece of paper or in code or whatever. Anything that is represented in some physical fashion, in writing or in electronic means, that's what you protect by copyright. It's the material representation of the idea. You don't have copyright in ideas by themselves. They have to be set out in some material fashion. That's what you copyright. Trademarks is some sort of a graphic or a mark or something you use in the marketplace to use to bring attention to your business, to uniquely associate it with your business. So they can have enormous commercial significance. And patents are different types of things that you can invent, different processes and things that are in inventions and original that you can get a patent protection on. Cybercrime. So this is a massive area in itself. And I don't know, again, I might just ask for a show of hands. Does anyone here either know or felt that they were interfered with in some way on their website that you might call, criminal interference? Anyone? Yes? Yes? So some? Yeah. I have. I recently had a major problem with someone somehow, and the analysis was that when I was, with your WordPress, when you get those updates, and this is what they, when they say, open source thing with WordPress, the danger there is always there, that somehow someone can get through to your site and to your platform and so on. And I think that's what happened. Well, it did happen to me. And what came through initially was these phishing viruses. So they got into my computer, and my computer was being used to send out all these messages to all sorts of institutions and organizations trying to get information from them, and it was sourced back to my computer. So, and that cost me a lot of time and angst and money to get that sorted out, and you have to get these things sorted out fast, otherwise they're going to close the site down. So the internet has many positives for society, but it also provides extremely effective tools and mechanisms for criminals to conduct unlawful activity. Such crimes can be committed quickly, inexpensively, and across an enormous geographical space, and have potentially devastating impacts on individuals, businesses, and governments. So how do you protect yourself? Know and use self-help measures. Make and use up-to-date and latest technology. Make it your business to understand the nature of unlawful conduct involving computers. There are 3 ways your computer can become involved in cybercrime. Your computer can be the target of an offense. which is what happened to me. A hacker hacks into your computer and steals, sorry, not quite this one, but steals private information, tries to cause damage to your computer or your computer network. Your computer can be incidental to an offense where an outsider tries to store information on your computer to keep it safe from law enforcement agencies. Your computer is used as a tool for committing an offense without you knowing. That's what happened to me. Yep, I'm finished. So I think we're pretty much, at the end. As I said, you're going to get these slides, and plus you can, if you use any of these methods here, and I think some of you will have those brochures and things, important thing is this: if you want to use me as an ongoing resource, because I'm on the faculty here for Street Smart, you need to let them know by leaving some sort of a note with them that you are interested, because then you can get invitations that I can send out to you, and I'm asking for your consent, your permission, that you want me to do this. So I can invite you into certain forums for business owners, places that can keep you resourced. And the whole point of that is this: when I speak to a group of business owners like today, and I say somewhere along the line that one of the big problems that we all have as business owners is, and it's not just like with this, I mean, if you're starting to have a dental problem, or your children are, of course your concern is, well, who's the best person to go through? And maybe I need a second opinion, but how many people do I have to visit and hear what they say and pay their fee to get to the answer I need and I want? I'm trying to dissipate that problem in the area of the law, so that by using me as a resource, if your first place is to come to one of those forums or to connect with me on LinkedIn and so on, you can raise issues safely in those forums, knowing that there's no one's going to charge you while you're investigating those questions. Where do I stand right now? What are the implications? What are my next best steps? What is the expertise that I need access to right now? These are all the fundamental first questions, and I don't want you to have to be concerned about getting those questions answered quickly, because it may count for a lot that you get answers quickly. And if I can't help you directly, I can certainly use my network to put you in touch with people that I believe have the right level of skill and credibility and so on to handle it for you. And I'm done. So there you go. Thank you.